Welcome to Hull on Estates, a series of podcasts for the Canadian legal community dealing with issues and insights surrounding estate planning in Canada. Hosted by the lawyers of Hull and Hull, the podcast will touch on some key considerations when planning estates and wills. Now, here are today's hosts.
Hi, I'm Jonathon Kappy.
And I'm Mark Lahn.
Welcome to Hull on Estates. You're listening to episode number 649. And today we are going to be discussing liability for persons who are not estate trustees of the estate. In particular, we are going to be discussing the decision of Humphreys-Saude and Pavao. How you doing, Mark?
Pretty good. Yourself, Jonathon?
I'm good. This is our first podcast together, so I'm excited.
Yeah, me too.
So why don't we jump into it? Why don't you give us a little recap of the facts? Interesting facts, and I think there are a number of legal issues that we can take from it. So let's dive in.
Absolutely. Yeah, the facts of this case are quite interesting. So the deceased Roy Saude died in 2019. So he was a man of fairly modest means, didn't have too many assets to his name, but shortly before his death, he had actually won an instant lottery. So he had won $77,000, and that was primarily the asset that was in dispute in this application. So Roy's daughter, who was the applicant, was named as the beneficiary of his will, and his mother, Mrs. Saude, was named as the estate trustee. The respondent to the application was the deceased sister, and she was also named as an alternate estate trustee under the will. And after Roy died, Mrs. Saude began using his debit card for her own personal expenses, and this included numerous ATM withdrawals, as well as one charge of $500 in paying the respondent's Rogers bill. So in total, there was approximately $13,000 in ATM withdrawals. And what was kind of notable was that several of these withdrawals were actually at drive-through ATMs, which Mrs. Saude didn't actually drive. So that required the assistance of the respondent. Now, in total, there was approximately $20,000 in withdrawals from his account using his debit card, of which $15,000 were found to not be proper expenses of the estate. So the respondent wasn't the estate trustee, but she actually assisted Mrs. Saude by participating in some of her activities as a estate trustee. So as I mentioned, she drove her around to make some of those ATM withdrawals. She was actually there on some of these transactions, such as at Costco, that were found not to be proper of the estate. And the evidence just demonstrated that she was aware that Mrs. Saude was using the deceased debit card. She shouldn't have been doing that. She certainly should have notified the banks to freeze the accounts. So she was aware of that. She kind of thought, what am I going to do? It's my mother. I can't tell her what to do. But she actively assisted Mrs. Saude in these activities. So what happened is Mrs. Saude actually died. Her estate was largely insolvent, and the applicant brought this application to figure out, can the respondent be held liable for a breach of trust for what she did in assisting her? So I'll turn it back over to you, Jonathon, to talk about some of the legal issues and what the decision was.
Sure. Well, listen, I think that ordinarily we see beneficiaries going after the estate trustees. They are the fiduciaries. They're the ones that are actively administering this estate. They're the ones that are liable for mistakes that are made, whether it's intentional or not. And this case is interesting because it talks about three different ways in which someone who is not the estate trustee can be liable to the beneficiaries for steps taken by the estate trustee, or even though they are not the estate trustees appointed. And those three principles are trustee de sans tort, knowing assistance, and knowing receipt. Okay, so the reason that it becomes important in our particular case is because the actual estate trustee died insolvent. So to the extent that that estate trustee was liable to the estate and to make good to the beneficiary for the withdrawing of cash and the misappropriation of funds, her estate had no money. So the beneficiary was looking for another pool of funds to go after in order to be made whole. So the first one that the court considers is trustee de sans tort. Okay, and a trustee de sans tort is someone who is not the estate trustee, either because they are not appointed under the will or because there is an intestacy and there is no estate trustee by default. But nonetheless, they hold themselves out as the estate trustee and begin to take steps to administer the estate. Now, I think it's important to note that it is not a breach of fiduciary duty to be a trustee de Santor. Just because you start acting, that in and of itself is not a breach of fiduciary duty. But if you do hold yourself out as a trustee and do take steps to administer, then you are accepting all of the responsibilities and liabilities that come about with being a fiduciary. And you can be liable as the fiduciary, even though you are not the named estate trustee in the will. And so in looking at this particular set of facts, the court said, well, this sister of the deceased drove the estate trustee around. She may have done some things as agent on the direct instructions, but she didn't represent anybody or take any steps by herself as the estate trustee. So we cannot regard her as a trustee de Santor. There was an estate trustee, that was mom, and only mom held herself out and administered this estate. So the court said there's going to be no liability on the grounds of trustee de Santor. The next one is a more common law tort, and that is knowing assistance. Okay. And knowing assistance applies where a person assists a fiduciary with knowledge that that fiduciary is carrying out a dishonest or fraudulent design, and they will be liable as constructed trustees. So in this particular case, even though the sister was not an estate trustee de Santor, if she knew that her mother was a fiduciary, if she knew that her mother was breaching her fiduciary obligations, and if she assisted, helped facilitate her mother to do that, then she can be liable as a constructed trustee to the beneficiaries. And that's what the court found in this case. And it's an upsetting result from one standpoint, in that this sister was helping her mom. Her mom was elderly, probably didn't know everything, all of her obligations, knew that she was taking money. I'm not sure how intentional and malicious her acts were, but more importantly, this third party, this sister, didn't really benefit from any of this. It's not like she got the money. Mom got the money. Mom used the money. I think that the sister may have gotten the benefit of about $500 for a Rogers bill that mom paid on her behalf, but most of that money she didn't see.
Yeah.
But she was found liable to the beneficiary for all of the money that was misappropriated by mom that she knew about, she knew what was going on, and that she assisted. And so the last one that the court didn't end up getting into is knowing receipt. And that one's a bit of an easier one to lay blame on, because knowing receipt comes about where you know a pool of funds arises as a result of a breach of fiduciary duty, and you accept it knowing that it's tainted funds. And that one's easy to, the court will consider you holding it as a constructed trustee. That one's it's a no-brainer that you got to pay that back. You can't, it's basically being in receipt of stolen goods at that point, right? You got to give that back. The knowing assistance one is harder because you don't necessarily receive a benefit, but you are going to get tagged with a liability. And that's what happened here. So it's something that's really important to consider. Just because you are not the estate trustee does not mean that you cannot be liable for steps taken with respect to the administration. And so if you are going to help someone, in some ways, you need to know what's going on. Now, we have to remember that knowing receipt and knowing assistance requires knowledge, right? This is not just a fault-based, you didn't know what was happening. You drove someone around, they went in, and you don't know what happens. You have to know that this is going on, and that's part of the test. So, you just have to keep your eyes open to be aware. Any other comments before we wrap this up?
Absolutely. Yeah. I mean, it really just highlights the important role that the estate trustee takes as far as accounting. The court was certainly very critical of some of the accounting that was provided here. The mother said, oh, my son owed me $10,000. There was no proof of that. So it really just goes to show, once you're appointed as a estate trustee or sort of a person surrounding that estate trustee, just really be careful, not only in your accounting, but also in how you're communicating with the beneficiaries as well. The court was critical of some of those actions as well.
Yeah, no, that's a very good point. So I think that concludes our podcast for today. Until next time, we want to thank you for listening. I'm Jonathon Kappy.
And I'm Mark Lahn.
If you have any questions, please email us at info@hollandhull.com or contact us through the contact page on our website.
This has been Hull on Estates with the lawyers of Hull and Hull. The podcast you have been listening to has been provided as an information service. It is a summary of current legal issues in estates and estate planning. It is not legal advice, and you are reminded to always talk with a legal professional regarding your specific circumstances. To listen to other podcasts or to leave a question or comment, please visit our website at hullandhull.com. Our theme music is Upper Structure by DJ A Kid and is courtesy of the PodSafe Music Network.